Good evening. We are so proud to stand before you and to tell you that when we announced the charges 15 months ago, we also promised that we would seek the truth for Trayvon Martin and due process for George Zimmerman, that we would get all of the facts and details of this very difficult case before a jury, and that we chose to do it that way because we felt that everyone had a right to know everything about this case. That for a case like this to come out in bits and pieces served no good to no one. As Mr. Guy told the jury yesterday, to the living we owe respect, to the dead we owe the truth. We have been respectful to the living. We have done our best to assure due process to all involved, and we believe that we brought out the truth on behalf of Trayvon Martin. There are so many people to thank, starting with Sheriff Esslinger and his entire sheriff's office. They've been so good to us, as has Michelle Kennedy and all of the people here. As you know, we traveled from our own circuit to be here, and that has not been easy, but it's been made so much the better by having so many people be gracious. You have respected our privacy, you the media, because we said after the press conference that we were going to try this case in the courtroom, not in the media. And we appreciate you respecting our privacy in doing that. I have an amazing team of lawyers, paralegals, and investigators who put their lives on hold and with me accepted the governor's assignment to take on this difficult investigation and this difficult case. And I'm so proud to stand here with them and to be part of the historical aspect of this case to show that the American justice system can and should only be done in a court of law. I don't believe it helps anyone for us to be out espousing opinions about our cases, and I think, as you see, we put this case in front of a jury, and that leads me to thanking the jury for the 16 hours of deliberation that they took to go over all of the facts and circumstances. What we always believed was that this was a case of details that had to be analyzed very, very carefully. I never could quite understand people, even people with law degrees, who had not read all of the police reports, who had not read all of the witness statements, yet who came up with opinions one way or the other. And this team of people standing with me, who stand with me every day in the Fourth Circuit and try tough cases like this all the time, knew that we had to do the best to get the entire facts and details of this case out and before a jury. I think this jury worked very hard. We honor them for their service. Judge Nelson worked very hard. We want her to know that we appreciate all that she did to keep this case on course. And of course, our hearts, as always, go out to our victims' family and to all victims of crime. But as long as they know that there will always be prosecutors fighting for the truth, I think that victims will continue to rely on this justice system. I'll turn it over. Bernie, would you like to say a few words?
I want to thank you all for respecting our privacy. I am disappointed, as we are with the verdict, but we accept it. We live in a great country that has a great criminal justice system. It is not perfect, but it's the best in the world, and we respect the jury's verdict.
John?
I'd also like to thank you for your time and attention that you've given this case. Both sides are deserving of your attention. We have, from the beginning, just prayed for the truth to come out and for peace to be the result, and that continues to be our prayers, and we believed they have been answered.
Rich?
I'd just like to say to the family of the dead teenager Trayvon Martin that I appreciate the way they have handled this matter. They've been dignified, they've showed class, they have kept their pain in check when they needed to, and they have grieved when they needed to. And I think that they have handled it like ladies and gentlemen. it can't have been easy and it won't be easy. So I ask that, I know y'all have a job to do, but when you approach all that, keep them in mind too. Thank you.
I also want to thank the thousands of people who sent prayers our way, held us in their thoughts throughout this entire process. We got a lot of encouragement from a lot of people. But again, this is something that we do in our circuit. We try a lot of murder cases. We never know what a jury is going to do. We go into every case putting our best case forward and leaving it in their hands, and that's what we did in this case. Is it appropriate to take questions?
Why did you overcharge?
Well, we charge what we believe we can prove based on our Florida standard jury instructions and based on the facts of the case. So that's why we charged second-degree murder. We truly believe that the mindset of George Zimmerman and the words that he used and the reason that he was out doing what he was doing fit the bill for second-degree murder. Second-degree murder is a general intent crime, unlike first-degree murder, which requires specific intent and sort of a design on the... I'm sorry, I wasn't finished with my answer. I didn't finish my answer. And so because it's a general intent crime, you look at the way the crime is committed. It doesn't have to be between two people who know each other.
Ms. Corey, what was the greatest challenge you feel like that your team faced in winning a verdict that would have been yours?
Well, I think that one of the greatest challenges we faced is taking over a case that had already been being investigated for as long as it was before we stepped in and were able to start conducting our own investigation. It was a challenge, but it's one we took when the governor assigned this case to us, and we did everything we possibly could. Yes, ma'am. Oh, I'm sorry. Would you just let me know, and I'll answer whatever you say. Thank you. Yes,
Jackie
ma'am.
Goddard for the Times of London and the Daily Beast. I just wondered if you're able to pinpoint one aspect of the case or one item of evidence or witness evidence that let you down on this.
Oh, well, we never would say that anything let us down. We are used to the imperfection of both witnesses and evidence in criminal cases. And we've all been trying criminal cases for a very long time. And you just can't guess before you take a case to a jury how something's going to turn out. So you work very hard, you put your witnesses on the stand, you argue your case to the jury, and then you focus on the law and the arguments, and then you leave it in the hands of the jury. What we promised to do was to get this case in front of a jury and give George Zimmerman and Trayvon Martin each a day in court. Yes, ma'am.
Ma'am, I'm sorry. Sorry, I didn't know that was you. Lisa Lampkin, NBC News.
Yes.
Can you tell me if you and the prosecution team have had a chance to speak with face-to-face Trayvon Martin's parents?
Well, I spoke with Sabrina earlier today. Do you mean since the verdict?
Yes, ma'am.
No, we have not. We actually came straight down here after the verdict.
Dana Shaban, WFTV. I was
Yes, ma'am.
wondering, do you think that the judge got it wrong with the felony murder based on child abuse, or were you just disappointed with that ruling?
Oh, thank you for asking about the lesser includeds. Schedule 2 lesser includeds are part of the standard jury instructions. Once you've tried your case, then you are to look at, obviously, second-degree murder. Manslaughter is a necessarily lesser included. It's a Schedule 1. And then if we believe the facts of our case fit any of the Schedule 2 lesser includeds, then we ask for them. A charge conference is usually a very basic part of a trial and doesn't require a lot of drama, quite frankly. So because Trayvon Martin was 17 at the time he was killed, we believe, because we believe it was an intentional killing, that the facts fit the third-degree felony murder. Third-degree felony murder is a non-enumerated felony. It's a complicated concept, but it is a Schedule 2 lesser included, which is why we requested it. We request our lesser includeds. The judge gives what she believes is appropriate, and that's how we try cases.
Ma'am,
I'm sorry.
David Ovalle from the Miami
David.
Herald. Can you talk about Florida Stand Your Ground law and whether the changes in the law in 2005 affected the facts in this case and whether this case could have been won perhaps pre the changes in the law?
Well, justifiable use of deadly force has changed to a certain extent. Stand your ground is a procedural mechanism, as we call it, where we fully expected, because of what we were hearing, that the defense would request a stand your ground hearing, and we would have put on the same evidence. It would have been in front of just a judge instead of a jury. Well, the duty to retreat aspect actually had sort of disappeared before stand your ground kicked in. You're talking about the Castle Doctrine, basically? And then how that got extended into public areas. Yes, it's a very complicated and difficult area of the law. I think I did allude to that pretty specifically when we first announced the charges. Justifiable use of deadly force is one of the most difficult areas of the law and one of the most difficult affirmative defenses to which we respond in our criminal cases. Yes?
Christy O'Connor, in the beginning of this case, as you know, the country felt that there was such a strong likelihood that you would prove that that voice was Trayvon's, and then obviously things turned around. Talk about that voice tape, whether, and also any other evidence that you thought was strong and what happened to it and how it affected you.
What was convincing to us when we listened to the tape is that the scream stops the moment the shot is fired. That's the kind of common sense evidence that prosecutors rely on every day. That scream stops when the shot is fired. And so we always believed, after hearing that tape, that it was Trayvon Martin.
Michael Anos with HLN.
Yes, Mike.
Piggybacking off that, was that the argument or one of the key ones you thought you had to win? Who was screaming for help? Maybe it was the severity of George Zimmerman's injuries. Did you feel you had to win those and maybe didn't?
You know, that's another interesting point because a lot of people said, why didn't we produce the photographs of George Zimmerman's injuries, the blood on the back of his head? Well, one of the reasons is because we didn't also produce the picture of his physician's assistant who said the cut was this big. So see, when you put together a case, you have to analyze all of it, not just what was going on right at the time of the crime. So those injuries, we believe, did not rise to great bodily harm. Children across this country, athletes, get injuries like that every day and go right back into the game. Or their parents kiss them after they've fallen off their bike and they go right back in. I'm not trying to minimalize this, but we did not believe that what the statements that were made by George Zimmerman comported with injuries of great bodily harm. And one of the other key pieces of evidence, as Christy asked earlier, was we don't believe that he could have been straddled and had the gun on that inside back holster and gotten it out if he was truly being beaten at the time the shot was fired. And so that's another key element in our decision to file charges. Yes, ma'am.
Hi, Lisa Lucas, New York Daily News.
Hi, Lisa.
Let's talk about Rachel Gentile's testimony. Were you disappointed in the result of that testimony? Do you think that damaged the case for you?
Lisa, we deal with witnesses to our homicides on a regular basis who are sometimes friends of the defendant, who are sometimes friends of the victim. A lot of them may or may not be educated. A lot of them may or may not have good memories. Eyewitnesses and ear witnesses come with just a realm of issues. And so you can't say that you're disappointed in them as long as you've asked them to take the stand and tell the truth, and you believe that your witnesses have done that. So, yes, sir. Oh, I'm sorry. I apologize for messing up the protocol. I apologize. Yes, ma'am.
Mrs. Corey, I'm Barbara Liston from
Yes.
Reuters. You said earlier that one of the greatest challenges of this case was taking over an investigation that had been handled by another agency for so long.
Yes.
Are you saying that the Sanford Police Department messed up this case? Might it have been
Absolutely not.
different if you had handled it from the beginning?
Absolutely not. What I'm talking about is the burden that it put on us to come in after the fact. The way we work shootings in our jurisdiction is we work side by side with the police from the time of the shooting. That's not a criticism of anybody. It just made it more difficult for us than what we're used to. No, I think during the press conference, I told you all that we believe the Sanford Police did everything that they could that night. Let me remind people again that when a citizen does a shooting, and it's not in the commission of a felony, a full-blown felony, like they're being robbed, they're being raped. It's sort of an encounter that happens like this in a mutual territory. Those are a lot more difficult, and we have to look at those very carefully. Justifiable use of deadly force is a defense that we look at when police officers have to take a life or have to apply deadly force, when citizens have to do it, and when it happens inside their dwelling or inside the store that they own, or during the commission of a forcible felony, that is so much easier of a decision to make. When two people are on mutual ground, and make no mistake about it, Trayvon had every bit as much the right to be on the premises that they were on as did George Zimmerman. Then that then goes to all the facts and circumstances behind the case. And that's why this case was unique in that sense, and that's why it was difficult.
Kathy Bellich with Channel 9 in
Hey, Kathy.
Orlando. Once you determined that you could not, well, once you found out that you could not determine who started that confrontation, why did you decide to go forward? Because isn't that a key point of a case like this?
I'll let Bernie answer that.
Well, I think we have to go back to the beginning. Who was following who?
I'm sorry, Bernie.
Who was following who? I mean, isn't that what this case boils down to? That was our theory. Now, we respect the jury's verdict, but really what it boiled down to is a kid minding his own business being followed by a stranger. And so I would submit that that's when it started. I don't know if that answered your question or not. Well, that's not the theory, that's the facts. Jury obviously disagreed at some point, and you'll be able to hopefully inquire of them of what they thought. But when it boils down to is you got a 17-year-old kid who is minding his own business, wearing a hoodie, and gets accosted, gets followed by an individual who wants to be a cop.
I do want to mention one more thing. This case has never been about race, nor has it ever been about the right to bear arms, not in the sense of proving this as a criminal case. But Trayvon Martin was profiled. There is no doubt that he was profiled to be a criminal. And if race was one of the aspects in George Zimmerman's mind, then we believe that we put out the proof necessary to show that Zimmerman did profile Trayvon Martin. But the right to bear arms is a right in which we all believe. I especially believe in that right. What we want is responsible use when someone feels they have to use a gun to take a life. They have to be responsible in their use. And we believe that this case all along was about boundaries and that George Zimmerman exceeded those boundaries. Yes, ma'am. I'm sorry. Yes.
Mr. Delarianda, just a quick question for you. You mentioned that you're disappointed in today's verdict. Can you talk a little bit? You guys put a lot of effort, a lot of time, grueling schedule, 17 months. Can you talk a little bit about that frustration that you might?
Well, let me make sure I say it clearly. I respect the jury's verdict. This is no criticism of the jury verdict. I believe wholeheartedly that we live in the greatest country in the world, so I accept it. But I am disappointed. I've been trying a lot of cases. I've tried 300-something cases, about 80-something murder cases. This is only my second murder case that I've lost. Am I disappointed? Yes, because I thought he was guilty. But what matters is what the jury said, and I accept it. I don't know if that answered your question.
Mr. Delarianda,
Yes, sir.
could I get your impression of the 2005 expansion of the Florida's self-defense statutes? Does this make your job harder?
You know, self-defense has existed for a long time. Right. And we've dealt with it in Jackson for a long time. We've tried a lot of self-defense cases. I personally have tried, 10, 15 self-defense cases. They're tough cases, but we accept them. So the law really hasn't changed that much. Stand your ground was a big thing, but really the law hasn't changed. And we believe in the right to bear arms and the right to self-defense. We felt in this case that it was not appropriate.
Hi, I'm Michelle Sunder with USA Today. John Guy talked about the fact that this was going to be a verdict that sent a message, and that it was going to be about what happens when a guy follows a young child and then shoots him. Could you tell me what you think about what this verdict means to the nation and what it says?
Yeah, I don't believe I ever said it was going to send a message. I mean, criminal cases are about defendants and victims. It's most instances like this one, a one-on-one confrontation. So it was a determination about what happened between those two individuals. I certainly didn't mean to characterize this as sending a message outside the courtroom.
One more question. Prosecutor Corey, this question is about Ben Kreidboss. Since
testifying in that pretrial hearing about discovery evidence. We understand that he was terminated. Can you talk to us about why he was terminated from your office?
I believe that we have released a letter that details why he was terminated. And again, we want to keep the focus on what we promised 15 months ago, which was to get all of the facts of this case in front of a jury or in front of a judge if it had been a stand-your-ground hearing. And I believe that's what we've done. I believe the focus needs to be on how the system worked and how now everyone in this country, because of you all covering this case, can say that they know the facts that were allowed in front of the jury, and now they know and can make up their own minds about the guilt of George Zimmerman, and know that this jury gave it a lot of time and attention. I don't think anybody will tell you that they don't appreciate how much the jury did. One more thing that I did forget to mention earlier is when you asked about second-degree murder, remember that the definition of that is an act or a series of acts. And we believe that the series of acts of Mr. Zimmerman and what he did leading to Trayvon Martin's death were why we were able to file second-degree murder. And I'm sorry, Jackie, was that the last question? Again, we want to thank all of you. We want to thank all of the people who have sent prayers our way. We want to thank, again, the people of Seminole County for allowing us to come in here and try this case. God bless you, and we do ask for peace and for privacy to the extent that Trayvon Martin's family wants that privacy. Thank you very much.